SJC-12394, Commonwealth v. Brandon Baez.
Thanks. That's okay.
Mr. Hennessy, good morning.
Good morning, Mr. Chief Justice. Pardon me. May it please the court, my name is Robert Hennessy and I represent the appellant Brandon Baez in this case. This case is here today on a reported question from the Superior Court, that being whether in light of Miller versus Alabama, a juvenile adjudication may be used as a predicate for enhanced penalties under General Laws Chapter 269, Section 10G. As a threshold matter, it's the appellant's position that this court need not reach this complicated constitutional question because a careful and reasoned statutory analysis of Section 10G demonstrates that interpreting its triggering phrase, which is having been previously convicted of a violent crime, in accordance with its plain language, this court's longstanding jurisprudence that an adjudication does not equal a conviction, and the substantive parts of Chapter 119, Section 53, saying that juvenile proceedings are not criminal proceedings, to preclude those persons who have not previously been convicted, but rather only adjudicated delinquent for committing such an act is not only a plausible construction implicating the rule of lenity.
That would require us to overrule 2 appeals court decisions saying the opposite, right? By Judge Cass and Judge Armstrong?
Yeah, and in particular, the Commonwealth versus Furr case, I believe that the second case cites back to Furr without providing a whole lot of additional analysis, but it would require you to look at and overrule the analysis in Commonwealth versus Furr.
We'd also have to figure out the problem that the Armed Career Criminal Act specifically gives a definition of conviction looking to Chapter 140, and within that is a juvenile adjudication. So that's sort of a difficult argument.
Well, actually, no. I think that the Armed Career Criminal Act, Section 10G, specifically refers to the definition of violent crime.
In 140, Section 121 gives
Correct.
a definition of violent crime that includes juvenile adjudication.
Absolutely, yes, it does. And I think that, as a rule of statutory construction, the more general definitions rule in Section 121 should not cast doubt or ambiguity onto the clear language of the more specific statute, Section 10G. Certainly not enough doubt and ambiguity to justify looking past the plain language of 10G.
Well, it doesn't work the other way. You have a general definition of conviction, and then the Armed Career Criminal Act gives a specific definition of conviction as it relates to that particular statute.
When you say general definition of conviction, do you mean in the law as a whole or within the statute itself?
The general, it would be consistent with your position. Doesn't include an adjudication of delinquency.
As a matter of law, the general accepted definition of conviction would not include a juvenile adjudication. Exactly.
But
Yes.
now, within this statute, they decide to use a more specific definition.
Well, they decide to use a more specific, or they decide to provide a definition for
Right.
violent crime. Nowhere in the statute does it say we're going to be defining conviction to include, in abrogation of the common law, to include juvenile adjudications. Not specifically. I mean, and one thing that's worth noting at this juncture is that distinguishes the Massachusetts scheme from the federal scheme, where on the face of the actual federal ACCA, they say a conviction shall be defined to include, among other things, a juvenile adjudication. The legislature chose not to do that in this case. Rather, what they do is they use the term conviction. They can be presumed to understand this court's prior distinctions between juvenile adjudications and convictions in that context. And then they go on to define violent crime as something broader than just convictions. And there's a reason apparent why they would do that. Now, a reason that was overlooked in Commonwealth versus Furr in particular.
That reason being?
That reason being that In the act of the act of the legislature that created Section 10G and also amended Section 121 to include this definition of violent crime, there were 3 other statutes that were amended to refer to the definition of violent crime in Section 121. If you just give me one moment. Those 3 statutory provisions are General Laws Chapter 140, Section 129B, which governs the issuance of firearm identification cards. The General Laws Chapter 140, Section 131, which governs the issuance of licenses to carry firearms, and General Laws Chapter 140, Section 131F, which governs the issuance of temporary licenses to carry firearms to non-residents of the Commonwealth. In all 3 of those statutes, again, all of which were created or amended by the same act of the legislature that created 10G, all of those statutes refer to having, as being applicable to people who have been convicted or adjudicated a youthful offender or delinquent of a violent crime as defined in Section 121. So the legislature's reason for having a broader definition of violent crime is apparent when you look to the other sections of the statute that are impari materia and were also passed with the same act of the legislature. It's because the legislature uses different terms in that same statute for different potential consequences. In the context of these consequences in which there's licensure consequences for having had either a prior conviction or a prior juvenile adjudication, they use both of those terms. In the one section that imposes significant and severe criminal penalties, they use the term conviction. And I don't think there's any reason to presume that the legislature intended a broader definition of conviction for that word they use.
But I'm trying to figure out what to. I'm not,
Okay, sure.
Put aside whether it's a good idea as a matter of policy with this point. So 269-10G says, whoever having previously been convicted of a violent crime, and then they look to 140, Section 121, for a definition of violent crime, and within the definition is any act of juvenile delinquency. So I'm trying to figure out what there is to interpret.
What there is to interpret is the legislature's use of the word conviction, or excuse me, previously convicted. Now, in the same, I think that the plain language of that, being previously convicted, it was well established.
As defined herein. Previously convicted as defined herein. And as defined herein includes in 140, 121, an act of juvenile delinquency.
I believe it's previously convicted of a violent crime as defined herein. I think as defined herein refers to violent crime, which the statute does provide a definition for. The statute does not provide a separate definition for the word conviction. And in the absence of a separate definition, I would submit that the plain and understood definition of that term at the time that the legislature passed the act should prevail and should govern. Now, this court has said that at the time that the legislature passes a law, they're presumed to understand previous statutes that they have also passed, as well as this court's explication of the law in its published decisions. At the time that this statute was passed, this court had made completely clear the fact that a juvenile adjudication is not a conviction. And that comes from the constitutional issues that might raise. It also comes from Chapter 119, Section 53, which says juvenile adjudication proceedings are not criminal proceedings. Therefore, it is not a conviction. It's something different than a conviction. Now, this is an issue that, point being is that we can presume that the legislature intended the common definition of the word conviction, and the common definition of the word conviction at the time that this statute passed precluded juvenile adjudications. Now, it is absolutely true that they then went on to define violent crime itself to include juvenile adjudications, but that's a cross-reference to that and other statutes, which themselves specifically say anyone previously convicted or adjudicated delinquent, passed within the same law. And within that context, it seems eminently clear or at least clear enough to create an ambiguity worthy of invoking the rule of lenity, that the legislature said what it meant and meant what it said, especially when compared to the legislature in the exact same act of the legislature using the broader terms which really would encompass both convictions and juvenile adjudications.
When you combine the language of convicted of a violent crime with the definition of violent crime, you effectively end up with convicted of any act of juvenile delinquency involving the use or possession of a deadly weapon that would be punishable by imprisonment for such term if committed by an adult. So the legislature would have understood that this so-called conviction would be by somebody who was committing an act of juvenile delinquency.
Well, so
And was a juvenile because they say that if committed by an adult, suggesting that they understood that this particular act would not be committed by an adult.
certainly, I would say that absolutely the legislature, it's clear on the face of Section 121 that they understood that a violent crime could be committed by a juvenile under certain circumstances. I think you're absolutely correct. That doesn't cast ambiguity on the fact their use of the word conviction in 10G and their use of the word convicted or adjudicated delinquent in other sections of the same statute. I think permitting the notion that what they're defining violent crime as may include a juvenile adjudication is completely consistent with them also, the legislature also saying, you know, in the context of licensure issues, we're going to allow these juvenile adjudications to satisfy the triggering responsibility. But in the case of this really very punitive criminal statute, we're not going to include convicted or adjudicated delinquent. We're just going to include convicted, and I think this court should presume that they understood what that meant and apply it according to the plain language. Now, one thing I'd like to point out is in Connor C, this court held that in the context of 269 section 10A, a conviction could include a juvenile adjudication. Now, in that case, which the court went out of its way to say was confined to the specific statutes that they're dealing with and made a point of saying that, you know, we're adhering to our general jurisprudence that a conviction is not, a juvenile adjudication does not qualify as a conviction. Really the reason that the court found it necessary to abrogate, at least in that narrow circumstance, this common law understanding was because in that case, construing the word conviction not to include a juvenile adjudication would have, to quote this court, would have impermissibly negated several provisions of the 1996 amendments in the face of a reasonable alternative construction. Specifically, the 1996 amendments, which I should point out is a completely different act of the legislature passed 2 years earlier. So to the degree that Commonwealth versus Furr seeks to import the intent of the 1996 legislation to the 1998 law, I think it's barking up the wrong tree. But what the 1996 legislation did, which was titled An Act to Provide for the Prosecution of Violent Juvenile Offenders in the Criminal Courts of the Commonwealth, the court, based on that title, among other things, found clearly that at the time of the 1996 legislature, the legislature intended to change the law regarding juvenile adjudications in the Commonwealth.
Can I get you away from this argument and get to the other argument?
Yes.
When weighing the proportionality part of your brief in the Miller factors, you say that this is malum prohibita, it's a regulatory offense. How do we reconcile your position with the statistics and the current national debate on firearm gun control with the gun violence we see in our streets every day?
Yes, of course. When I said that this at its root I'm talking about Section 10A at this point, the actual offense conduct is essentially a public welfare offense. I was quoting Jackson when I said that. This court in Jackson.
Yeah, right.
And I am not in any way in making this argument disputing that there are significant societal harms that are attendant to.
Is possession of a machine gun a regulatory offense?
mere possession of it and not using it, I would say it is a regulatory offense. I'm not suggesting that there are not significant societal harms from guns and gun violence in the Commonwealth and in the country more broadly. All I'm saying is that when you consider the actual offense conduct of passively possessing a firearm that you are not allowed to possess, it is distinguishable from more malum and se crimes like actually acts of violence using that. I'm saying that although the threat of harm is unmistakably present with any case involving a firearm, actual harm is not present. I was just making that distinction. I was not suggesting in any way that gun violence is not an issue that the legislature needs to combat or wouldn't be justified in doing so.
Before you sit down, am I correct that this argument based on statutory interpretation and the rule of lenity was not made before Judge Muse, and as far as I can tell, was only made in your reply brief?
I would say that this issue of statutory interpretation is raised in every case that raises a substantial or grave constitutional question.
Try my question. Was it raised before Judge Muse, or was it raised in your brief apart from your reply brief? I don't recall seeing it except in your reply brief.
It was not raised before Judge Muse. In fact, I mean, the briefing before Judge Muse was in large part Judge Muse's own procedural order, which identified his interpretation of the law that was going on, and then he invited defense counsel to file a motion which didn't add much to that. So Judge Muse did not raise that sua sponte as part of his procedural order.
And was it, I mean, I saw it in your reply brief. I don't recall seeing it in your blue brief. Am I wrong?
It was not asserted, certainly not to the extent that it was in the reply brief. The opening brief, the principal argument I make is I identify Fur and other cases, and then I argue that the evolution of understanding represented by Miller, Diachenko, and their progeny necessitates a new look at mandatory sentencing laws.
That part I saw.
Yes.
Okay.
It's alluded to right in your summary of argument. Sort of.
It's alluded to in the summary of arguments, but really it came into clearer focus. Well, two things. One, under the doctrine of constitutional avoidance, and also under this case law that says that when considering a reported question on Rule 34, the court should consider all dispositive issues short of reaching that issue before they reach it. But also, it's alluded to in my opening brief, it really came into greater focus when the Commonwealth, in its brief, argued at length how the clear intent of the legislature made the reported question and appellant's arguments with regard to it an improper and unjustifiable interference with the primacy of the legislature. And then also in terms of the Commonwealth 16L letter, which it filed afterwards, focusing further on the statutory construction argument in Anderson, it came much more to light, and then the full-throated statement of it was in my reply brief.
Just one last question. I take it the legislature did not address this in the way the bill that passed yesterday. It's not adjusted this penalty.
I don't have an answer. My only understanding of what passed yesterday is there was an effort to increase the jurisdiction of the juvenile court to 19-year-olds. That was
There are a lot of
taken out.
There are a lot of mandatory minimums that have been adjusted, but I suspect, at least my reading of the newspaper, didn't include this one.
I'm sorry, I don't have the answer. I'd be happy to report it via 16L letter if you think it would be helpful.
Okay. Before you sit down, since we took so much of your time on the statutory construction, you're not going to have a chance to respond. The issue here isn't the length of a sentence. The issue that Judge Muse reported has to do with whether or not juvenile delinquency adjudications or youthful offender adjudications can be predicates for habitual offender statutes. And what we have here is nothing having to do with the length of a sentence. We have an adult being sentenced, an adult, not a juvenile being sentenced, an adult being sentenced. And even in Perez, we've never extended the reasoning of Miller or Danchenko beyond analyzing parole eligibility for murder. So that's a lot to get over.
Yeah, I absolutely concede that this is a significant extension of the law that is suggested in the reported question. And I've obviously at this point rest on my brief to explain why I think that those extensions are warranted in this case.
Thank you. Mr. Zanini.
Good morning. May it please the court, John Zanini for the Commonwealth. I will try to be brief. First of all, the report is not appropriate and should be discharged without answer for 3 reasons, 2 of which I mentioned in the brief. One is that this would be a 1 or 2 day trial. The motion to suppress the firearm, which was seized on this defendant's person, has already been denied. There would be probably 2 police officers and a ballistician, something along those lines. So this would not delay the trial and should never have been reported. The second reason is that it is impossible to assess the proportionality provisions, the nature of the offender, prior to a sentencing hearing at which all of the offender's conduct is put in front of the sentencing judge in order to try to then later assess whether or not this punishment is disproportionate. So without that information in the record, which I could give you lots of information which indicates 10 years is appropriate for this defendant, this is not an appropriate question. And the third is, as you just alluded to, Chief, the issue now being argued was not raised below. It is not in the reported question. It was not briefed in the defendant's initial brief. So the question he wants the court now to decide under the doctrine of constitutional avoidance was never reported to the court. And under the same doctrine of constitutional avoidance, the best way to avoid the issue is just discharge the report and send it back. Wait until after sentencing.
Sounds like you're saying that there may be situations under which a defendant in this position might not deserve the minimum mandatory.
I am not saying that. What I am saying is if you were to have a more full record, it would certainly inform the court's review of the appropriateness of the legislative decision-making that people who are violent recidivists and commit violent crimes as juveniles and then up the ante from knives to guns when they become adults should in fact face 10 years of mandatory imprisonment in order to deter their conduct, in order for retribution to be imposed, in order for rehabilitation to take place.
So in order to impose and apply the 3-part Cephalotus standard, there needs to be a sentencing where the judge presumably, at least out of caution, is going to consider the Miller factors, and we just don't have that right now.
Well, I don't think the judge has to.
Well, forget that part of the question. That's not.
Setting aside
that's not, as you know, the point of my question. But going to your point, not my point, going to your point, you're saying if we're going to apply this 3-part test, then let's see what happened at sentencing and what was considered at sentencing, and then we have something to apply.
Absolutely, and I suggest the same.
You're assuming that Judge Muse would deny the motion to dismiss, which she may not.
Well, since there is no legal basis to dismiss the charges, I'm assuming that the good judge will follow the law.
But
some
of course,
judges do
he's
and
asking us
some
what
don't.
he's asking us what the law is, so that he can decide the motion to dismiss.
What the judge said was he had a visceral reaction to the idea that this person would be sentenced to 10 years in state prison rather than 18 months, which was his usual notion of a sentence for carrying a firearm, when he knew nothing about this person other than the fact that he had 2 prior violent offenses involving the use of a knife to assault people and rob people. That was his visceral reaction. A judge has a duty to set aside his visceral reaction, recognize his biases, recognize his prejudices, set those aside, act fairly and impartially, and enforce the law as it's written by the legislature, unless the law is unconstitutional.
But you can't have it both ways. You can't say we should discharge the question and then essentially tell him to deny the motion. If we discharge the question, we don't answer it, and he'll have to decide it without our guidance.
I understand that, and I'm assuming the law is so clear in this area that he's going to deny a motion to dismiss, since there's no basis to dismiss the pending indictment.
That'd also give you the opportunity to flesh out the predicate crimes so that there's a record of what this person did as a juvenile, which we don't have other than the charges.
Certainly, we could flesh out the fact that in a period of just under 4 years, in 8 separate criminal incidents. He was adjudicated delinquent 18 times. 4 of those were violent offenses, 3 involved knives, and 2 are these predicate offenses. We could also potentially flesh out the fact that the firearm that was seized in this case is the basis of other indictments now in Superior Court because he shot at 2 people and hit one of them. So he's indicted on those offenses. He's also indicted in federal court under RICO because those 2 shootings are the predicate offenses for the RICO charges, where he's facing, on a plea, probably 10 years in federal court. So we could flesh all that out.
And Judge Muse will undoubtedly get a motion to dismiss based on the statutory interpretation that we just heard. And if he allows it, we'll see you again. And if he denies it and there's a conviction, we'll see the issue again, but we'll see it when it actually happened.
Yes, and in order to, the motion to dismiss has already been filed, it just hasn't been acted on. And, you know, getting beyond proportionality, when you get to the shock the conscience substantive standard, as this court set forth in O'Neill in 369 Mass, that standard ultimately is a disproportionate standard. So no matter what you do, you've got to get to the disproportionality issue. These kinds of sentencing issues are appropriate post-sentencing.
Is that always as applied? That test?
Right. It seems to be an as-applied test, except O'Neill was a death penalty case, and so that is the exception. In this jurisdiction, notwithstanding the fact that after the court held the death penalty unconstitutional the first time, and then the Constitution was amended by the people to reenact it, it was then held unconstitutional again. So that's sui generis, the death penalty. Nothing else is in that category of unconstitutional sentencing, except the juveniles are eligible for parole after 15 years.
And whenever we've dipped our toe in the Miller water, it's been based upon the particular offense conduct in the offender.
The nature, right, more specifically the fact that the offender is a juvenile and thus is subject to rehabilitation over the course of time. And this person is an adult, so Miller, Diachenko, those cases.
No, I understand that. I understand the federal circuits have reached this in your favor as well.
Yeah,
on the felon in possession in the federal ACC.
Yes, every federal circuit that I found that dealt with the issue was contrary to the defendant's position. And all of the state, I exhaustively looked at the states and briefed the states, and most states still have transfer systems in place. So a person in this individual's position would potentially be transferred to adult court, even as a person under the age of 18, and all of these prior offenses would then count for enhancement.
I think you might, go ahead, I'm sorry.
And we don't know whether or not the other states, because you both argue the other states, and we don't know whether or not this person would be subject to transfer under the other states' statutes, because we don't know anything about him because of the nature of the record.
Correct. But I think the bottom line for that is there is no national consensus that conduct that a person engages in prior to the age of 18, for which they are culpable, whether you call them delinquent, youthful offender, or otherwise, that conduct can be the basis for subsequent enhancements. That's the national consensus. Unless the court has other questions.
Just my own curiosity, I take it this mandatory minimum was not one of the ones changed yesterday, right?
That's correct. So my understanding of what happened with the passage yesterday was the one provision that references 10G says that it cannot be expunged, even if it was a juvenile. So it's such a serious offense, it can't be expunged. The other point I wanted to mention on statutory construction is in 2014, 10G was amended. The part that was amended, though, was just the age. It went to age 18. So under the doctrine of statutory construction, the legislature, having been aware of Connor C. and Furr and Anderson, knew that this court interpreted the statute in a way to include in the acts of juvenile delinquency, amended only the age provision, and therefore, as a matter of stare decisis, the prior interpretations have effectively been adopted by the legislature as of 2014. The other problem with the statutory construction argument defendant makes, as the court points out, is The definition of violent crime, first in Chapter 140, Section 121, first speaks in one sentence of adults. The rest of the entire definition is acts of juvenile delinquency that are violent and involve the use of a weapon. You would have to read out most of the text of Chapter 140, Section 121 in order to adopt the defendant's statutory construction of violent crime under 10G. And I don't think the legislature intended to adopt only the first sentence of that provision rather than the entire provision.
Well, I think his argument is focused not on the definition of violent crime, but on the meaning of the word convicted.
Agreed. And as the court ably has done in the past, they've said that word conviction means what the legislature said. It means acts of delinquency under 140, Section 121. Otherwise, you're reading out most of that statute. Unless the court has other questions, I will rest on the brief.
All right, thank you.
Thank you.